Okay, so the core aim of this conference is to develop a research-based concept of the risks of unsustainability. So for my presentation, I'm going to focus on how I think about corporate governance through the lens of risk. And this will involve stage setting by reference to some recent work that I've done in this area. And then I will turn to some applications that I'm exploring in current work. Now, in a recent book, I suggest that corporate law policymakers, practitioners, and academics alike have all exhibited an unproductive tendency to view the corporate form as a sort of fixed essence. And I'm arguing in response that we would do better to reject that sort of approach in favor of a more dynamic one. Now, many of us were probably taught that a corporation intrinsically involves this set of fixed attributes: legal personality, limited liability for shareholders, unfettered share transferability, centralized management through a small group of directors, and an exclusive franchise in the hands of equity holders, being the shareholders in a corporation. In my book, however, I argue that we should think of the corporation as a flexible form of legal technology that we can calibrate and recalibrate in varying contexts over time in pursuit of a wide range of goals. Now, on this view, the corporation embodies a set of governance levers that we can adjust in various ways. Decision-making power can be more centralized through a board, or it could be more dispersed in the hands of shareholders and/or others. Directors can face more or less liability exposure, which is going to affect their risk incentives. The less exposure they have, the more comfortable they're going to be with risk, and the more exposure they have, the less comfortable they're going to be with risk. Board composition could be determined solely by the shareholders, or other groups could be granted some degree of representation as well. Boards may be required to focus only on shareholder interests, or they might be given flexibility or perhaps even a mandate to consider other interests as well. Shareholders could be given more or less capacity to advance their own interests through lawsuits filed at their own initiative, either exclusively or in tandem with similar powers that could be given to others involved in the corporation as well. Shareholders can be given more or less freedom to sell their interests in the business, which can have a wide range of differing effects on corporate management. And shareholders themselves can face more or less liability exposure, which will affect their risk incentives in much the same way that it does for the board of directors. Now, these flexible capacities can be visually depicted as a set of governance levers that we can set in different ways and in different combinations. Now, fundamentally, corporate law does not innately require prioritizing financial returns above all else, and does not innately legitimize unlimited cost externalization. Rather, the corporation provides a number of dynamic capacities that, if we thoughtfully calibrate them, could help us grapple with corporate risk in a more productive way. So in this light, my book aims to expose the contingency of prevailing approaches and then to illustrate the potential benefits of alternative approaches in terms of how we calibrate these levers of governance. So, for example, depicted in this manner, the archetypal US public company looks something like this, exhibiting a strong board elected exclusively by shareholders, greater emphasis on generating returns for shareholders who can further advance their own interests through substantial capacity to bring corporate lawsuits, a high degree of investment liquidity, and then limited liability exposure for boards and shareholders alike. But of course, the critical point is that there's nothing inevitable about this. We could calibrate these levers in quite different ways toward differing ends if we chose to do so. Now, the first step here is combating the notion that this configuration represents some sort of scientifically deducible optimal state. That's a misconception that's perpetuated by Chicago School of Law and Economics literature, which obscures the reality that each of these was a contingent policy choice when it was undertaken. Now, in the book, I examine each of these governance levers and give historical and contemporary examples of how they might be calibrated to promote corporate sustainability. Now, given the subject of the conference, I'm going to focus here on one particular dimension, the relationship between liability exposure and risk. The conventional rationale for limited liability focuses on promoting shareholders' comfort with entrepreneurial risk. But what's less widely acknowledged is the corollary. If we want less risk, then revisiting limited liability is a natural place to start. It stands to reason that carving back at limited liability and thereby augmenting shareholders' exposure for corporate harms would curb shareholders' enthusiasm for unfettered risk and perhaps inspire monitoring to constrain corporate risk-taking. Now, history provides vivid examples of different ways to configure the governance levers with an eye toward constraining risk and combating the externalization of costs. For example, in the late 19th and early 20th centuries, corporate law sought to limit risk in banks, and in the US, this took the form of greater exposure for shareholders and boards of directors alike. Bank directors had a more demanding duty of care, and shareholders faced double liability rules, under which shareholders of a failed bank could be assessed up to the sale price of their stock to create a fund for the benefit of depositors, who were, of course, a category of creditors. Some states went further, treating depositors as beneficiaries of directors' duties. Now, the aim here was to stabilize banking by reducing risk and cost externalization, and relative to the calibration that we noted predominates among US public companies today, we can see here with this historical approach to banks, the sort of moderating effect that this configuration had. Some, myself included, have argued that abandoning these sorts of structures contributed to the risk-taking that led to the global financial crisis. In any event, while this sort of structure is most often associated with banks, it's important to note that similar approaches were sometimes adopted in other industries as well, notably taking the form of partially paid up shares, which have functionally similar effects. For example, double liability rules on the one hand and shares that are 50% paid up on the other place shareholders in the same sort of position. Either way, the shareholders have a sort of residual liability that's equivalent to the amount initially paid for the stock. So maybe we ought to rethink liability structures in banks and perhaps more generally, as several scholars have suggested in recent years. Why not revisit shareholder liability as a means of constraining socially harmful risk, most obviously in financial firms, but perhaps also in essential non-financial firms that give rise to similar moral hazard concerns? Here we might think, for example, about a company providing essential infrastructure that's regarded as too big or too important to be allowed to fail, and then also in inherently hazardous industries as well. Scholars have advanced creative proposals to this effect, but this hasn't gained much traction to date. So why is that? Well, we might start by reflecting on why it is that double liability rules for shareholders died out in the first place. Macy and Miller, in their study of US multiple liability rules, point to the extremity of bank failures following the onset of the Great Depression, which in turn triggered heavy assessments of retail shareholders who were already struggling, and some of whom may not have fully thought through what holding assessable stock might involve. So gradually, multiple liability rules were abandoned across the US in favor of greater reliance on deposit insurance, which provides an effective antidote to bank runs, but does so at the cost of greater moral hazard, which continues to plague us today, not only through deposit insurance itself, but also through implicit guarantees of institutions that are considered too big or too significant to be allowed to fail. So concerns about potential effects of reintroducing assessable stock shouldn't be lightly dismissed, because just as history demonstrates that multiple liability rules were an effective way to curb risk, history likewise demonstrates that the mechanisms for shareholder monitoring on which this risk mitigation strategy depends are far from perfectly efficient and could in fact result in real pain for retail shareholders who may remain passive and fail to fully appreciate the risks that they would be bearing by holding these instruments. Now, these are legitimate concerns, but I want to suggest that there's reason to believe the prospects for mitigating corporate risk-taking through liability structures are actually greater today than they were a century ago. Now, appreciating why requires drilling down on what the core regulatory strategy here is. The idea is to force creation of a fund that's available for external corporate harms, which forces internalization of costs that would otherwise be externalized. So if shareholders are forced to bear those costs, they should adjust what they'd be willing to pay to account for this exposure. Higher risk businesses would face higher costs for equity capital, and lower risk businesses would benefit from cheaper equity capital, deterring abuses and in turn incentivizing risk management. Now, there's a sort of simple elegance to this story in the abstract, but it does raise a number of practical questions. What should the degree of liability exposure be, and how do we determine when that's actually triggered? How do we avoid swinging to the opposite extreme, leaving investors so fearful of liability that they're just not willing to invest at all? More generally, where should the fund reside? Should it reside with retail shareholders themselves, or should it reside elsewhere? And if so, where? Now, with the remaining time, I'll take up these questions, and I'd put to you that although these challenges are real, they're not as substantial in the modern financial world as they might at first seem. Now, even though shareholder liability is often treated as if it were a crude on-off switch, there's actually ample capacity to fine-tune such exposure. For example, when you canvass proposals advocating a return to assessable forms of stock, you find several means of very precisely calibrating exposure to avoid excessive risk aversion. It could be keyed to a multiple of stock investment, it could be keyed to a fraction of stock investment, or it could be imposed pro rata. We could specify a liability cap, or we could exempt certain assets from assessment. Likewise, such exposure needn't apply to all shareholders in a given corporation. For example, it might apply solely to those exerting control within a given institution. Similarly, this might apply to a broader or narrower range of entities. For example, we might focus on those entities that actually have systemic significance, at least as a starting point. Critically then, as Hansman and Crackman recognized all the way back in 1991 when they proposed unlimited pro rata shareholder liability for corporate torts, we can't forget the impacts of indirect investment through intermediaries, which could affect degrees of risk aversion and potential for engagement by shifting the analysis effectively to big, sophisticated market professionals. Now, this directs us back to the question of where such a fund should reside. Should it reside with retail shareholders or with some other form of institution or some other participant in the business? Now, assessable stock implicitly locates the fund with retail investors, but it could just as readily reside with the company itself. This reflects the fact that assessable stock on the one hand and capital requirements on the other are actually similar strategies. The difference is simply that the former places the fund with shareholders while the latter places it in the company's own accounts. In this sense, we can imagine a sort of spectrum between retail shareholders at one extreme and corporate management at the other extreme. This is reflected in post-crisis proposals that present assessable stock on the one hand and regulatory capital on the other as alternatives. Either adopt assessable stock or maintain a bigger capital buffer. Nevertheless, both prompt familiar concerns. Leaving the fund with retail shareholders resurrects fears of traumatic assessments, but leaving the fund in the corporation itself prompts fears that management might fail to respect the integrity and purpose of the fund, say through creative accounting to manipulate relevant balance sheet categories. I want to suggest that there's a third way that's not only feasible, but represents the likeliest mode of implementing such a regime. As we all know, there's been a widespread shift over recent decades away from holding stocks directly toward investing indirectly through institutional intermediaries. So think of the likes of big index funds, big mutual fund families, and so forth. Now, if assessable stock were adopted today in any particular industry or more generally, who would actually end up holding it? It wouldn't be retail investors. It would substantially be institutional intermediaries, and this may actually present an opportunity. Now, if assessable stock were substantially held by institutions, then the sorts of concerns noted earlier wouldn't loom so large. Institutional intermediaries are obviously more sophisticated and engaged than retail investors are, and they wouldn't share management's incentives to deplete the capital buffer if the institutions themselves had real exposure. Perhaps sophisticated intermediaries present an opportunity to constrain corporate risk-taking and to force internalization of corporate costs, bringing them to bear on the price of equity investment in a real and substantial way without falling prey to the practical problems historically associated with assessable stock and capital requirements in the general corporate context. Now, I don't mean to suggest that it would be simple to operationalize all of this, but if we're serious about forcing internalization of costs, then I think this is where we really ought to be focusing. And the regulatory challenges aren't necessarily unfamiliar. If assessable stock largely landed with institutional intermediaries, then the challenges would become determining what meaningful capital regulation and related disclosure rules would involve in this context, which of course are forms of regulatory problems that are at least broadly familiar. Now, if we were to go this route, we'd be forcing major institutions, which have certainly talked a lot about sustainability, to act in a more tangible way and to communicate that credibly to regulators and beneficial investors alike. Now, I'll close by looping back to the broader framework that I began with. Could reforms like this be enough to deliver corporate sustainability on their own? Of course not. Nothing I've said is meant to suggest that this could substitute for other reforms, including who has a seat at the corporate governance table and what the core duties of corporate decision makers ought to be. Note also that none of these elements of regulatory architecture that I've been talking about address how to quantify various forms of risk, which obviously varies a lot from one context to another. The argument is not that the sorts of reforms I'm describing would be sufficient. The argument is, however, that something like this may prove necessary. Fundamentally, I think we probably need to be pulling all of these governance levers, shareholder liability included, because I doubt that we could fully achieve corporate sustainability without getting a broader range of corporate risks priced into corporate equity. Okay, thanks very much, and I will look forward to any comments and questions.